My name is Kelley. I am from Plymouth, Massachusetts, and I am speaking tonight in opposition to the land into trust application. I join our Governor Deval Patrick and our Attorney General Martha Coakley in their opposition to the land into trust process. The Bureau of Indian Affairs regulations for NEPA that treat lands held by the Indian tribes as federal public domain lands, subject to the NEPA regulations of the Bureau of Land Management for federal public domain lands in the western states, do not even apply in the Commonwealth of Massachusetts. The EIS scoping process must first address the authority of the Secretary of the Interior to even consider placing lands purchased by the casino investors for the tribe into federal territorial ownership under 25 U.S.C. 465 and 25 CFR 151. This statute, as written by Congress, did not intend or delegate any authority to the Secretary to place lands into federal territorial trust status in a Commonwealth that is one of the original 13 colonies, with preemptive sovereign authority over all of the lands within its boundaries. Every American citizen today living in the Commonwealth is under the civil, criminal, and taxing authority of the Commonwealth, regardless of race, ethnicity, creed, or religion. This has been in place since the Indian population of the Commonwealth were made full citizens of the Commonwealth, 82 years before they were made full citizens of the United States. In an act in 1834, the Indians of the Commonwealth rights were given back, the first selectmen and school committee were chosen, and from this event, the Mashpees date their release from civil bondage. The rights of the people, in the meantime, gradually enlarged. Their lands, which had been held in common before, were partitioned among the Mashpees, 60 acres to each, and the deeds duly recorded. The allotment was made in open meeting, and they then owned their land to enjoy all the civil and political rights of the Commonwealth. The Mashpee Indians have been assimilated into the mainstream of American citizenship since that date. There is no federal public domain lands or federal reservations currently existing in the Commonwealth, nor has there ever been, nor can any be created under 465. That regulation only applies to other federal public domain lands that may be added to existing federal Indian reservations for the use of an Indian tribe. The property clause...
Thank you.
Oh, thank you. Thank you, and I will turn this in.
Yeah, you can turn that in. You'll also, if you'd like to speak after everyone is signed up, you'll have another opportunity.